and Article 28 kicked in. We are no longer now looking at the expediency of the impeachment, but looking at the rights of that particular individual, the right to life, right to equal protection before the law, right to the dignity. That is what we were looking at. The Senate ignored all those. But what does Wambora tell you? Wambora case tells you, look and see whether there was a violation of the rights. Your Lordship, our submission is that there was serious transgression of those rights. Your Lordship, permit me to draw your attention to section, as I go to my next point, Article 138 of the Constitution. Clause 2. It speaks about the procedure at the presidential elections. I will draw parallel later. If two or more candidates for the president are nominated, an election shall be held in each constituency. My interest is the word each constituency. When looking at this, Your Lordship, and having submitted earlier that the office of the deputy president are derivative of the office of the president, when the Nation Assembly was called upon to initiate public participation, they were supposed to initiate this public participation in the same manner and the same mode this particular person they're removing from office came into office. You reckon, Your Lordship, that in the case of Maina Kiai, it was decided that the election is at the polling center. That election at the polling center, Your Lordship, is the most minute space where the people can exercise their sovereignty. So if we are putting in a president and the deputy president at the polling station, how do you remove him at the county headquarters? How do you make relevance of the county headquarters being the forum for public participation? How did my mother in Karusho participate in the removal of the deputy president? Yet that removal affects her sovereign will. So, Your Lordship, I will draw you to an affidavit by my friend David Madenge. David Madenge is not just another individual. David Munyi Madenge is a member of the County Assembly of Kirinyaga. He says at paragraph 9, paragraph 11, that he participated in that process. He has even annexed photos in that particular affidavit where individuals were blocked from accessing those so-called public participation forums. This is an elected member. His affidavit must be considered in the weight it deserves, having been a member who is already enjoying the sovereignty of the people. And again, Your Lordship, when you're looking at this affidavit, again look at the annexure marked as PP, as DMM1. This is the National Assembly announcement or notification of the extension of the public participation. They quote and rely on the decision of your brother, Justice Mwongo. Justice Mwongo, and that is the reason why my learned friend, the Member of Parliament for Kirinyaga, Honorable Njiiru, referred to the notice of motion that brought forth these particular orders, was specific as to the forums where the public participation was to take place. The judge was therefore reading Article 138, Clause 2, that we must go as close as possible. We must decentralize as much as we can to ensure that there is meaningful, there is quantitative and qualitative public participation. But when you put it in a notice like this, my mother at Karusho, she hardly reads newspapers. She hardly reads newspapers. And Karusho, Your Lordship, is about 130 kilometers from where we are seated. We also have individuals from where we are seated in Banisa who are 700 kilometers from where we are. A newspaper is published. Tell me how Gallo, how Muhammad, how Hassan had the ability to participate in this process. Just become pragmatic, my lords. View it in that lens. The pragmatism of what was being called upon. That is when you're told that there was no qualitative or quantitative public participation, your lordship. There cannot be any other answer to that. Your lordship, as I sum up, permit me again to draw your attention to Article 50. Article 50, Clause 2, Paragraph H. Your lordship, the deputy president was unable to attend to his defense. Most importantly, your lordship, for this court to note, is that the deputy president was the only witness for that case. He was not to call any other witness. And he has been denied an opportunity to defend himself. You will hear my learned friend, Senior Counsel Tom Ojenda, telling you that Article 50, Clause 2, Paragraph H, permits such kind of a conduct. It says, your lordship, every accused person has a right to a fair trial, which includes the right, H, to be present when being tried, unless the conduct of the accused persons makes it impossible for the trial to proceed. I am very sure they would have relied on that, your lordship. Let me preempt them. Your lordship, two things here. In Wambora's case, Wambora indicates, that is Wambora, the locus classicus, that the process of the impeachment is neither criminal nor civil. Therefore, this provision cannot be taken as an exemption to create the necessity for the deputy president to be available during the process of the impeachment. Because it's distinguished that this specifically applies to an accused person. And Wambora has said that an impeachment is neither criminal nor civil. So there was no possibility, your lordship, that his presence could have been done away with. It was mandatory, your lordship, for the deputy president to be present during the trial. As I sum up, your lordship, you might then ask yourself, in the circumstances, your lordship, where an individual has not been heard, where a person has pleaded his unavailability as a result of illness, what was available for the Senate to do? I sat through, I was present, Senior Counsel Paul Moite making an application for adjournment up to Tuesday. They rushed as if London was burning to deny that right. What was the reason, your lordship? They said that this was a time-bound process. That's a fallacy. That is a legal fallacy. This was not a time-bound process. And I'll look at it in two ways. If we were to say, your lordship, that the impeachment was to take place at the committee stage, there were 10 days provided for. If you were to say that the impeachment, therefore, was to take place as it did in the plenary, there were no rules requiring or giving the time period within which that process must be complete. May I repeat? When they opted for the plenary, and when they failed to modify this process so as to bring into conformity with the circumstances of the case and to create the necessary legal procedures for the impeachment, they went for it in a blanket manner, because the plenary itself did not prescribe the time period within which this impeachment must be completed. Your lordship, to the extent that this Senate failed to grant the deputy president an opportunity to defend himself and hid behind the timelines, which are not constitutionally provided for because they went for the plenary, then, your lordship, there was a transgression of Article 25, which provides for the non-derogable rights and a transgression and a violation of Article 50. We cannot look at it in any other way. There were no rules. The Speaker did not guide the members of the Senate as to how the plenary was to proceed if it were to sit as a quasi-judicial process. Lordship, as I invite my learned friend, Mr. Nyamu, permit me, Your Lordship, to urge you to admit these petitions. I equally associate myself with the submissions made in petition by the first petitioner and all the petitioners who have submitted before. But again, look at the affidavit of Honorable Njeri Maina. Again, Honorable Njeri Maina is not any other person. She's an MP, a member of parliament, who sat all through in that parliament, who sat and contributed to that motion. When she tells you that in her constituency there was no public participation, who am I to deny? Who am I not to believe her? She's elected. She has a distinct, identifiable constituency that her affidavit speaks about. Your Lordship, permit me to invite my learned friend, Mr. Nyamu, and urge you, Your Lordship, to find that there was no impeachment at all, and my Lord, to quash the said impeachment. But while quashing it, Your Lordship, again remember that there is nothing unjusticiable before you. The question of justiciability has been dealt with in the case of Wambora 21, and again, the case of unjusticiability, Your Lordship, that constitutional virginity was penetrated when Article 165, Clause 3, Paragraph D was enacted. That this court can penetrate the works of the Senate, the works of the National Assembly, to see to it whether it was done in accordance to the Constitution. It no longer enjoys that constitutional virginity. Mr. Nyamu. Thank you, Lordship.
Thank you.
Thank you, my lords and my lady. In the interest of justice and